Welcome everyone to today's webinar on the UN Guiding Principles 10 years later with the Business and Human Rights Journal. My name is Jen Malott from Cambridge University Press. And before we get started, I want to quickly go over a few items just so you know how to participate in today's event. Everyone has joined in listen-only mode, but you will have the opportunity to submit text questions by typing your questions into the Q&A box on the control panel. You may send your questions at any time during the presentation. The moderators will be watching the chat and will collect those and address them during the session to discuss later on. If we're unable to get through all of the questions during the session, we will add them into a Q&A document that will go around with the recording after the webinar is over. If you experience any technical difficulties, please add those into the Q&A box as well, and a member of the organizing team will endeavor to help you. And in the unlikely event we experience any issues, we will message the audience and restart the webinar. Everyone can just jump back in. The whole event should take approximately 70 minutes. The first 10 will be the tribute to Professor Ruggie, followed by a series of short presentations and speaker responses. There will be a few minutes at the end as well for more questions from the chat. And to get everything started, I'm delighted to turn things over to Anita Ramsastry, who will introduce the panelists.
Great, thank you so much, Jen. And it's my pleasure, along with my co-editor-in-chief, Michael Santoro, who will moderate our discussion later today, to welcome you to this webinar, which is really reflecting on a decade of the UN Guiding Principles on Business and Human Rights. And we're also using this opportunity to pay tribute to Professor John Ruggie, who was the architect, along with his team, of the Guiding Principles, and the journal was honored to publish one of his very last pieces of scholarly work, which Caroline Rees, one of his team and colleagues and the founder of Shift, will be discussing today. We're going to begin, I think, with a reflection on John Ruggie's contributions. I should mention, and then I'll introduce the panelists as we transition to the next section, who are our authors from the symposium on the 10 years, is that Professor Ruggie has there was a memorial service for him this past weekend at Harvard University. And while many who were gathered there reflected upon his contributions to the Guiding Principles, the architect, and his career as that architect, there was also equal number of professors from the world of political science and international relations reflecting on his work as a scholar in a larger sphere. And it's, I think, those two worlds connecting that bring us what we have in the Guiding Principles. And so with that, we'll watch a short video of one of Professor Ruggie's last presentations on the next phase of the journey on the Guiding Principles focused on mandatory human rights due diligence. So I'll share that video, and Caroline Rees, who's here with us, can tell us a little bit about that, and she helped select this, and then we'll reflect a bit on his work and contributions before we jump into our discussion. So thank you. Caroline?
Thanks so much, Anita. Yes, and the excerpt comes from a webinar that John did with and for the Nova Centre on Business, Human Rights and the Environment, with actually the support of the Portuguese presidency of the European Union, who did it earlier this year, in January of this year, in looking at human rights due diligence as set out in the Guiding Principles, and particularly this move towards mandatory human rights due diligence, including civil liability. So it was a stage, you'll see, where physically he was a little unwell, but mentally he was right through all of the last months very much engaged in the depth and breadth of the debate and anticipating this important movement towards mandatory human rights due diligence.
Great, thank you so much, Caroline. I'm just going to now share my screen and we'll play a brief video to listen to Professor Ruggie in his own words.
So I'm supposed to talk about due diligence and liability. I'm sure by now everyone has committed the due diligence principles of the UN Guiding Principles to heart. I won't say very much about it. Say a few more words about liability, a subject that was addressed only briefly in the Guiding Principles. I think you know that human rights due diligence is a central feature of the UN Guiding Principles, intended to enable businesses to identify, prevent, mitigate, and account for potential and actual human rights harm that may result not only from their own activities, but also through their business relationships. Now, quite deliberately, we adapted the term due diligence from the world of business because it is a concept that business is familiar with. But we insisted that even though you may be familiar with the core of this, there are critical distinctions that you have to bear in mind as you go about doing human rights due diligence. First of all, in a most straightforward sense, human rights due diligence is not a transactional process. You're not looking to buy a piece of property and you want to make sure that there's a title to it. You are undertaking a long-term relationship with people, and the focus needs to be on those people whose lives and activities and possibilities you can affect. And that means that stakeholder engagement is absolutely critical to human rights due diligence. It's a distinctive feature. It does, and it's different from the way, obviously, in which other people are thinking about stakeholder capitalism, if you will. It's an attempt not to identify general classes of stakeholders like employees or communities or consumers whose interests should be taken into account and define those ex ante. The guiding principles are exactly the opposite. It takes the company to the people. And engagement and learning from the people whose lives you are about to affect, and acting on risks is the key is a key difference between the transactional due diligence practiced by business and human rights due diligence. My third point is that it's quite plausible, and I've seen it done, that human rights due diligence can be included within a broader enterprise risk management system, as long as these differences are respected and taken into account. And as long as the company isn't simply looking for material risks, by which they mean risks to the financial risks to themselves, but rather looking for salient risks to people they are impacting, which a traditional risk management system might not catch early enough. Now, a little sidebar before I get on to liability. If you make a due diligence system mandatory, the way in which it is being discussed in Brussels, and if the requirement exists for a serious due diligence process and reporting on due diligence, it becomes a legal responsibility for the company. And it requires the company to address and report, which in turn has implications for the governance of the company. The management has to collect and aggregate the data of risks, of failures, of successes, and report them to the board. They become responsible as they would for any other area. And so through a human rights due diligence system, you actually affect corporate governance in a much larger sense. You don't have to fiddle around with trying to rewrite directors' duties. You know, directors are there, they're just got a new job or an additional job. And I think that's the extraordinary potential of a human rights due diligence system.
As you can see, Professor Ruggie's intellectual contributions continued up to this very day as he jumped into the debate in the European Union on mandatory human rights due diligence. I'll just reflect for a couple of minutes before we then turn to all of the scholars we have assembled for discussion today, just to reflect on Ruggie's work as an international relations scholar. A survey in Foreign Policy magazine has identified John Ruggie as one of the 25 most influential international relations scholars in the US and Canada. And many of us know him, of course, through the Guiding Principles, and his book, Just Business, Multinational Corporations and Human Rights, has been translated into many different major languages of the world. But many of us don't really know him as the international relations scholar that he has been throughout his career. And so for many of us teaching in business and human rights or writing in that field, I would suggest reading his earlier work because it really informs how he thought of the Guiding Principles and business and human rights. Now, Ruggie introduced a couple of key concepts that I'll just mention briefly to you. He introduced the concept into international relations of something adapted from the scholar Carl Polanyi, which is the term embedded liberalism. And he used that in his scholarship to explain the post-World War II international economic order and the creation of these multilateral Bretton Woods institutions that we see today. And his article entitled International Regimes, Transactions and Change, Embedded Liberalism in the Post-War Economic Order was published in 1982 in International Organization. And it's one of the most highly cited studies in international political economy scholarship today. But that article really focused on the concept that markets were not divorced from people or from social norms, and that in fact, as a way to deal with the impacts of the market as an abstract concept, one needed to embed within the rules of the market social and liberal principles, such as the welfare state and other things that we see in a post-World War II new order. And so the concept of taking social principles and rules and regulation to constrain markets is very much something that informed his work and scholarship. And we'll post a link to the 1982 article, but I commend it to you. A second piece was that he was a major contributor to this idea of constructivism and this constructivist approach to international relations, which takes very seriously this idea of norms, identities, and ideas alongside other factors, that world affairs and global affairs are socially constructed, and they're not basically sort of in the neo-realist school where rational choice and behavior of actors such as sovereign states make only utilitarian calculations about how to maximize benefit. That people, ideas, and norms can also help shape the direction of international relations. And the North American school, of which Ruggie was a leader, emphasized the role of social norms and identities in constructing international politics and foreign policy outcomes. And so when you hear these terms and you think about them, you can think very much about the Guiding Principles, which was an exercise in norm creation, very much driven by ideas of many kinds of people, influential decision makers, of course, but rights holders on the ground as well. And so another article that I commend to you, which looks at this distinction, is one that calls What Makes the World Hang Together, Neo-Utilitarianism and the Social Constructivist Challenge, which he published in 1998 in International Organizations. And then the third trend I would say is really focusing on global governance and new governance, and the idea that governance really is not just about state-created decision-making. And so he joined a lot of other international relations scholars in this endeavor as well. And there's another article I would suggest, which is one from New Global Governance called Global Governance and New Governance Theory, Lessons from Business and Human Rights. So just to say that John's views and writing on the market, on liberalism, looking at constructivism and social norms, one can very much see a trajectory in terms of the UN Guiding Principles on business and human rights. So as we reflect on the Guiding Principles today, we should step back and think about John Ruggie's life work and how that contributed to that framework. With that, I'm going to turn it over to my colleague, Michael Santoro, who will be leading us in a discussion today. We have several of our authors and scholars from different perspectives. And John Ruggie loved debate. So he loved agreement, disagreement, and trying to work to make things even stronger and more effective. So I think he would have enjoyed hearing from scholars today. We have Caroline Rees, who's the founder and president of SHIFT, with us, who worked very much on the guiding principles with John Ruggie. We have Professor Peter Muchlinski from SOAS, who is really, again, one of the giants in the field who really helped us focus on the law of multinational enterprises. We have Professor Andreas Rasche, who's a business ethicist and scholar or management scholar from Copenhagen Business School. Professor Nicola Jägers, who is from Tilburg University, and again, someone who has been a leading scholar in business and human rights since the inception of the field. And then, of course, my dear colleague, Professor Michael Santoro from the Levy Business School at Santa Clara. And again, Michael, over to you for some interesting discussion.
Thank you, Anita. Thank you for Caroline for sharing that wonderful video of Professor Ruggie. I was just struck by how brilliant it was and how I learned new things even from this video. Just when you think that you can't learn anything further from Professor Ruggie, he reminds us about the centrality of people. I loved how he put that in his talk to the whole UNGP endeavor. So just a quick word about the format. Each person, we will have 2 scholars paired. Each scholar will speak for 4 minutes and then a 2-minute reaction from the other, and then 3 minutes of surreply from the original person, and then 1 minute for audience questions. There's a Q&A down there, which we can see all of you participating. If there's a lot of questions, we'll introduce them into the 3-minute surreply. So it's 4 minutes, 2 minutes, 3 minutes, 1 minute, total of 10 to everyone out there. Caroline, Professor Ruggie spoke for himself, so you're meant to be the first speaker and to present the paper that you wrote together, and Professor Muchlinski is meant to reply, but this puts you in a hard position, right, having had Professor Ruggie speak. But if I can turn it over to you, under that great burden, that we'd be most grateful to hear your thoughts on the paper that you and Professor Ruggie wrote for the journal.
Thank you, Michael, and indeed myself and John and Rachel Davis, my colleague as well, all 3 of us in the writing. Well, I consider the video well selected because it leaves me with much less to need to say. But it really, and Anita's comments as well, really speaking to that backdrop of John's academic thinking. And as he said himself a couple of years ago when talking about the evolution of mandatory human rights due diligence, he referred to the guiding principles as not being merely a text, but intended to help generate a new regulatory dynamic. And in many regards, this paper is looking at 2 examples of that dynamic. One direct and happening, the trajectory into mandatory human rights due diligence, and one indirect and promising, which is this idea of stakeholder governance, multi-fiduciary duties. So first of all, we look at how the guiding principles, through this interplay, this polycentric governance, as John would put it, the interplay between civil society pressures, government and legislative responses, and growing corporate acceptance, even some support, have moved us from an initial stage where governments were putting out national action plans on business and human rights, honestly, often more retrospective descriptions than forward-looking action plans, through to the use of human rights due diligence in piecemeal legislation, modern slavery, child labor, reporting regulations, and now to the fact of human rights due diligence legislation in some individual countries and the prospect, of course, of it in the EU as a whole. And that's exactly, I think, the kind of regulatory dynamic which was foreseen in the very construct of the guiding principles. But second of all, then, we look at how this is beginning now to interface with a parallel and somewhat independent development with regard to the shape of capitalism and corporate governance. And here, of course, we've seen growing momentum in the last 2 or 3 years for a move away from the idea of shareholder primacy and towards a new stakeholder capitalism, recognizing that the incentives for business to externalize costs and risks onto workers and communities in order to maximize returns and shareholders, and as part of that broader internationalization dynamic of global supply chains, that has been a significant contributor to the unconscionable levels of inequality in our societies today. And so companies need to become more accountable, not just to their shareholders, but also to these other stakeholders. And John alludes to this. It's absolutely the case that under this proposed stakeholder capitalism, the categories of work of stakeholder being cited as needing attention are so broad that its implementation could actually end up being little more than business as usual, right? I mean, employees can be seen as addressed through existing engagement efforts, health and safety provisions. Suppliers can be viewed in terms of having good relationships with their management. Communities can be seen as taken care of through philanthropy and staff volunteering, and nothing changes until you bring this into a connection with the guiding principles. And first, as John was indicating, just the guiding principles make clear that if stakeholder capitalism is to mean anything, then the focus must be squarely on those people in each stakeholder category whose basic dignity and welfare is most at risk, right? The lowest paid employees, those who aren't even directly employed and in more precarious situations lacking benefits and security, the workers of your suppliers who are at particular risk, the communities whose health or livelihoods are undermined by how business gets done. Suddenly, it's a much more clear picture as to who needs to be in the focus of attention. And then you take this to that interface with mandatory human rights due diligence, that evolving situation now in the European Union. And this proposition becomes an obligation of companies with civil liability attached. And thus, as John was saying, it enters the boardroom. It now becomes part of multi-fiduciary duties of directors. So it's through this dynamic interplay that we see that while one can and likely should continue to press for changes directly in corporate governance regulations, there is a second and perhaps nearer term pathway that can take us pretty far towards a stakeholder capitalism with multi-fiduciary duties for boards through the very practical implications of mandatory human rights due diligence.
Thank you, Caroline. That was a perfect 4 minutes. Peter, if you can you do a perfect 2 minutes for us?
I'll try. The two core issues, first of all, can human rights due diligence allow us to have legally binding obligations? Now, one of the things that strikes me is the similarity between the component elements of due diligence and the evolution of a duty of care, because you have to foresee classes of victims, of people at risk from your behavior. You have to take reasonable steps to avoid foreseeable consequences that are harmful. And so there is of course, you need to have some sort of causal relationship. So there are links here between existing legal categories, such as duties of care and human rights due diligence. But one of the problems that this raises is that it's a kind of self-judging process, that we don't have an external third party analysing this until such time as maybe a failed due diligence process becomes an act of litigation. And so there's still quite a long way to go between changing corporate behaviour and how that might integrate due diligence, and how far we can actually hold corporations liable for failing to perform due diligence. This is a very, very grey area still. We're not quite sure what the parameters are, because there are obviously some very important questions about how we obtain a just result. If a corporation has done everything in its power to avoid harm, but harm nonetheless occurs, what is the extent of that responsibility? Is it simply the procedural responsibility to follow due diligence, or is there something more? Now, the other point on the stakeholder capitalism, as you know, you yourselves in your paper considered the impossibilist theorem that is charged against your position, in terms that it's never possible for business actors to identify and then satisfy the multiplicity of stakeholder interests. And I would say that is a reality. There is a choice here, and it goes back to my earlier point that corporations will still have quite considerable leeway and control over what they're going to be doing in this context, and that we need to think a lot further about.
Excellent. Peter, another 2 perfect minutes. We're going to spoil everyone with our timing. Just a quick point before I turn it back over to you, Caroline. There's 2 functions going on now. There's a chat function where everyone can share comments and references. There's also at the bottom of your screen a Q&A. If you have a question to the panel, that is where to put the question rather than in the chat room. Anita, you're also watching the chat room in case someone places it there, that's fine. But if possible, please put it into the Q&A function at the bottom of your screen, you can see to the right. Caroline, time for your SIR reply and discussion with Peter. I'll turn it back over to you. We have 3 minutes now for this discussion between the two of you.
Yeah, no, thank you, Peter, for those observations. And I think, I mean, just to take the one about self-judging, right, that it's self-judging until it fails. But I think that sort of assumes that it's just sort of in the realm of corporate sort of decision as to how this gets done, through to the point at which there's a judicial process that says, no, that wasn't it, that wasn't right. But I think it misses all of the dynamics in between, right? It misses the fact that actually there are a number of forces at play here. We're looking at the civil society response, the media responses, the investor responses and engagements. And of course, all of these are evolving and growing their own forces and their own interaction points with this, not least the investor engagement around this, right? What are their and should their expectations be? But also that national enforcement, and this is where, you know, we're doing quite a bit in the EU context at the moment, to say you're going to have national enforcement bodies needing to understand what makes for good and what doesn't, right? So it's not just once one arrives at the court, there are other interactions that can happen here to, for sure, be in a grey space, right? And here, to your point about, is it a standard of conduct, it is a standard of outcome? Well, fundamentally, yes, it is a standard of conduct, because other than in some situations where it literally is straight causation and entirely within the gift of the one corporate actor, many of the issues we're looking at here are highly complex, with many forces coming to play and making them happen. And the company has a critical responsibility, but is not a sole causative factor in that. And so we need to be able to appreciate and integrate that complexity into how judgments are made and what judgments are made. And the fact that it is messy is a reflection of the human reality, I think, rather than some fundamental flaw. And I remember John used to hearken back to Amartya Sen sometimes, and saying how he looked at how we needed not to sort of incarcerate these ideas in pure law, such that social logics and these complexities cannot play out. We need all of these levers, all of these dynamics in play. We can't simply solve it through saying, let's get everything into a court of law with one single actor responsible for it all.
Peter, did you want to reply?
I think that my point is made more for dramatic effect, because the problem that we have is how far do legal responses to human rights problems really matter? After all, litigation is itself a very problematic activity. I guess we're suffering from the fact that we're at the very beginning of these processes, and it's only sort of recently that, for example, the Canadian Business and Human Rights Ombudsperson has been established, and we still don't know what that institutional process will create. But I think it's very important to stress that the UNGPs are about changing behavior, and they're about creating processes where people can reflect critically upon their own decision making. And that as such, this is a social process. And I think that sometimes lawyers can lose that. I mean, I find it's quite hard from my own disciplinary background to actually break free of legalistic categorization of behavior. And I think that maybe we need to stress this far more, that social norm change is actually extremely important in improving the outcomes of people's lives, which is essentially, I think, Caroline, what you're saying. We need to look at the processes that businesses are engaged in and the whole institutional and social network around that, and that legal claims are just one thing, and they may not be the best thing to do. But unfortunately, we are seeing a translation, whether we like it or not, of the human rights due diligence concept into legal norms, and we're seeing litigation on the back of that. So I think we've got a whole new chapter of problems there.
Leave it there, Peter. Give Caroline, if you can take one last word, and then we'll reverse roles here.
Yeah, absolutely. Well, I mean, thank you. I think that's very much indeed where our thinking converges here, Peter, that, I mean, the law really matters. It really does matter in this. It is a critical part of the picture, and it's there in the guiding principles and the dynamics we're seeing, I think, are very constructive and productive. But as you rightly say, ultimately, this is about mindsets and behaviors, and laws can get us only a part of the way there. They are only part of the force that needs to happen. We need to move beyond voluntarism. Yes, we also have to move beyond compliance, because compliance alone cannot get us to where we need to get.
Absolutely.
Peter, we now turn to you for your primary presentation.
Right, well, thank you very much. Well, my contribution to the special issue sought to look at a different angle, which was, what has the UNGPs done to the business attitude to human rights in business? Because that's something I've been around a long time. I can remember a time when talk of business and the responsibilities for human rights was simply non-existent. And indeed, I described this period in my paper as the period of business defensiveness, when business simply rejected any claims of responsibility for human rights. And that period, which roughly coincides between, say, the mid-70s and the end of the 80s, the only statement of responsibility for human rights pertaining to business was in the draft Code of Conduct on Transnational Corporations, paragraph 13. But on the whole, nothing else happened. For example, the OECD guidelines and the ILO tripartite declaration on multinationals were both silent on human rights issues. But then something changed in the 1990s. By the end of that decade, corporations were actively addressing how to ensure that their operations were human rights compliant. And we have, in my paper, I have two examples. First of all, the apartheid era and the whole campaign for corporate divestment. And secondly, Shell's realization from the Niger Delta situation that it had a responsibility to think about human rights. And one of the very important elements in this, which we shouldn't forget, is that Amnesty International itself shifted its focus. Amnesty, through the work of the late Sir Geoffrey Chandler, who set up the Amnesty International UK business group, actually made the link between human rights and business behavior. Although, having said that, I should also stress that states remain the primary movers behind human rights violations, rather than just to suggest that corporations are the main culprits. But the third period, the period where we are in now, I think, is what I call institutionalized voluntarism. And one of the things that the UN guiding principles do is, I think, institutionalize the idea of business responsibility for human rights by the three pillars. First, the state duty to protect. It creates an institutional imperative on states to regulate, but the corporate responsibility to respect creates an imperative on businesses to arrange their decision-making systems in a particular way that is conducive to the avoidance or at least mitigation of human rights risks. And business seems to be responding, albeit slowly, to that imperative. Although it's very easy to dismiss the UN guiding principles on the basis that they are an outcome of business influence, because there are no mandatory standards in there. But the problem is actually, as from our earlier discussion, is how do you actually articulate the idea of a social norm which has power, as opposed to a legal norm, which is generally seen as being more powerful than a social norm. But that's another debate. Now, my paper finishes with the question of what happens beyond voluntarism. And in a sense, Caroline's earlier presentation has already talked about that. But I think from a business attitudes point of view, you will see continued opposition to liability in the courts, with an acceptance of the need to have some kind of clarity and certainty in the law through the new mandatory human rights laws. Now, partly this is a political question as well, because if you kind of don't like capitalism, you're going to assume that business is going to do everything to thwart these things. But if you realize that capitalism is here to stay, the question is how to humanize it. And business may be able to do something towards that.
Caroline, over to you.
Yeah, thank you, Peter. And it's a terrific overview of this evolution, as you say, in decades, right, of business attitudes towards their responsibilities in society. And I mean, I'm intrigued by the concept of institutionalized voluntarism, not as applied to the Global Compact, which I think is a fair representation, but more as applied to the guiding principles, because as you know, right, John was involved both in the conception of the Global Compact, which is very much an idea about companies choosing to sign up to the 10 principles and then having this context within which they're promoted and share best practice, advanced conversation, very particular role and vision. But it was also really, really clear that the concept of the guiding principles, the conception, the construct of the guiding principles was fundamentally and intentionally different from that. And I see very much where you're coming from with this sort of the institutionalized, sort of within state institutions and the business internalizing this due diligence process. But it's the voluntarism piece that I think I find stretches. During the process of the mandate, we really pushed back on this sort of dichotomy between voluntary and mandatory, which I think is, and maybe here as well, Peter, is really more about not a legally binding document and a legally binding document, because voluntary and mandatory can become much grayer than that. There are many ways in which things can become less than optional. And we were clear in the guiding principles that respect for human rights is not optional, but is an expectation of all companies everywhere. And that may seem like semantics, right? If the guiding principles aren't themselves a legally binding instrument. But I'd suggest that it's actually the very power of that proposition, once it's endorsed by the UN, echoed by national, supranational bodies around the world, that is the critical pivot point away from voluntarism. And essentially, it says respecting human rights is no longer a sign-up proposition, right? Civil society no longer has to argue case by case and from first principles that there are clear responsibilities of companies. Legislatures now have a rallying point for the development of the laws. And so the guiding principles have precisely been, I would argue, the lever that moves us out of voluntarism rather than being an institutionalized voluntarism. And so given your recognition that domestic law is as much part of the guiding principles as is the human rights due diligence process, that they've given that regulatory dynamic towards mandatory human rights due diligence, it seems something of a leap to maintain that they're still about voluntarism if they're not an internationally binding instrument. I just want to probe into that and what I'm missing here.
Caroline, thank you. We have a comment from Professor Erica George. I think, Peter, it might be directed to you. She said that Human Rights Watch also made tremendous early contributions to identifying the link between business actors and rights abuses with an early The Price of Oil report on the Nigerian situation. I suspect that was a friendly amendment to your historical account, Peter.
Well, in my book, Multinational Enterprises and Law, I specifically mention Human Rights Watch in this context. It's simply time constraints, but I think it is there. I certainly find both of those events, both the Amnesty International and the HRW developments of very major importance. I think I also mentioned that in my early 2001 article in International Affairs. So I fully agree with that comment. Is it time for me now to respond?
Yes.
Yeah, Caroline, I think this is a problem I'm wrestling with the book that I'm working on at the moment, is just how to actually describe the nature of the obligation in the UNGPs. And why I sort of went on institutional voluntarism was because as a lawyer, I do maintain there is actually a relevant distinction between the binary divide, legal, illegal, non-legal, legal, in the words of Gunter Teubner. And so I think that I'm being a bit of a positivist there, but perhaps that's a limitation of my own discipline in a way. I take on board, because I'm also very aware of, as we were saying in our earlier discussion, of the interaction between non-legal forms of enforcing human behavior. And so, yeah, it's problematic. It's a label, but it's not something I live or die by, quite honestly. It was just that the first thing that came into my mind is the binary divide between a non-binding instrument, a soft law instrument, and a hard law instrument. And I think many international lawyers have this same problem with the UNGPs. If you read the various debates on the relationship between binding and non-binding rules, but I'm closer to your side of the argument than you might think, I think. And then in my forthcoming book, you'll probably find that is the line I take.
And I think, Peter, just to wrap out on that, I take no issue with the legally binding, not legally binding distinction. I just don't think it's necessarily the same as mandatory and voluntary, right? Because those terms are broader concepts, and there are different things in society that make things de facto mandatory than the law alone.
Yeah, and this is what I have to do for the forthcoming book, is actually make that much clearer than I have done in my previous work, I think.
Well, thank you very much, Caroline and Peter. That was a wonderful discussion on both papers, and thank you both for your wonderful contributions to the journal. And now we will turn to our next panelists, Professor Nicola Jägers and Professor Anita Ramsastry. And I will turn it over to you. I think we're going to begin with Professor Jägers. Is that correct, Anita?
Yes.
Yes. Thank you so much, Michael. And thank you to all organizers for inviting me and giving me this opportunity to speak here today at this tribute to Professor Ruggie. It was really nice to see him on the video just when we got started. Professor Ruggie has left us a great legacy. We've seen, since the adoption of the UNGPs, we've seen these unprecedented developments. Professor Muchlinski was just referring to them in law and governance, but perhaps more important than that sometimes very slow or uneven developments in law and regulation is the fact that the UN guiding principles have provided us with a lingua franca, with a common language that has been embraced by both private and state actors, which has enabled this dialogue on business and human rights. And it's a narrative with corporate responsibility and accountability for adverse human rights impacts at its very core. And it's actually an article by Caroline Rees, also here today, where she points out the potential of this business and human rights narrative in influencing other narratives, in aligning policy areas that triggered my interest to write the contribution that I did for the special issue. So in my article, I explore the extent to which we can witness this business and human rights narrative indeed influencing other dominant narratives, bridging the often very much siloed approach to global issues. So this problem of fragmentation in normative and institutional activity is well known, and we very recently again witnessed this siloed approach. Just as an example, early October, the Human Rights Council for the first time recognized that there is such a thing as a human rights to a clean, healthy and sustainable environment. And then practically happening at exactly the same time was the Conference of Parties in Glasgow, where the outcome document practically ignores human rights. The decade that we saw the adoption of the UNGPs, we also witnessed two other interwoven narratives, which gained further profile with the adoption of two global instruments. So we saw the Paris Climate Agreement being adopted and the Sustainable Development Goals. And these narratives on climate change and sustainable development have proven very influential, have gained a lot of traction in the international community of states and international organizations and also the private sector. So what I researched for my piece in the journal was whether I could find traces of the business and human rights narrative in these, which might be seen as competing narratives or rival narratives. So I looked for these traces in the documents themselves, but also in subsequent state practice, in state reporting. And what we can see is that this dimension of corporate responsibility and accountability for human rights is largely lost in the environmental sustainability narrative. The UN Guiding Principles, or the core elements of corporate responsibility, are not or hardly mentioned, not in the Paris Agreement nor in the Sustainable Development Goals. While it's clear that commitment of the private sector is critical, right, for mobilizing the vast financial resources and for providing the technological innovations that are needed to meet the goals that have been set. And we see that the perspective towards the private sector in this context is very much one of partnership, right? So, but it's at the same time increasingly apparent that a transition to a global greener economy can actually come at the expense of human rights. So emerging efforts to incentivize and recognize voluntary actions by corporate actors should build on the UN Guiding Principles as the international agreed standard regarding the responsibility of the private sector for the protection of human rights. Yet this doesn't really seem to be the case. Very little attention is given by states in the context of the Paris Agreement or the SDGs to the business and human rights narrative. Instead, states choose to use rather vague terminology where there's little common understanding of its meaning. So what we in fact see happening, that brings me close to the end, what we see happening is a continued prevalence of the perpetuation of the more CSR kind of narrative, the corporate social responsibility narrative, linking business conduct in this context very much to philanthropy. So that leads me to conclude that in these competing narratives, business and human rights to date does not reach its full potential yet, and doesn't really seem to function as this guidepost for states on how to involve the private sector more in reaching environmental sustainability goals in a manner that actually recognizes their human rights responsibilities. Thank you. I hope I stuck within my time.
Well enough, Professor Jägers. Anita, over to you.
Thank you so much, Nicola, and thank you, Michael. I agree with most of what Nicola has just told us, right? That again, looking at Caroline's piece and the intention of the guiding principles was norm creation. And then as Nicola's piece mentions, right, is there permeability? Are we moving those norms into these other major global debates and addressing those related and interlinked global challenges? And I have to wear both a hat as an academic, but as a member of the UN Working Group on Business and Human Rights, because we're confronting those same things as we recently looked at the first decade of the guiding principles. So I think the main argument is yes, we don't have policy coherence nationally or multilaterally, and we do have these silos, right? These different kinds of narratives, these different norms, and they're really not in any way strongly connected. So as we look at the environmental framework, of course, that's true. That with the Paris Agreement, business and human rights wasn't on the ground floor. Similarly, with the Sustainable Development Goals, I would say that actually it's shift. It's the Office of the High Commissioner. It's the working group. We've all spent time arguing for how that the guiding principles should be the basis for sustainable development, that respect for human rights, mitigating harm in any number of areas relating to the SDGs would really move sustainable development and Agenda 2030 forward. But those are few voices, right? We don't see those voices amplified by governments, by business, or by the UN itself. And so we have to ask ourselves, why is this happening? And one thing I would just ask, I have two questions for Nicola, but one is about focusing a little bit more about the role of the private sector, right? To some extent, is this a convenient siloing for them? Because again, the language of sustainable development, positive contributions, choosing voluntarily what they do, is that a better narrative? Is it a better narrative for states to talk about the ways in which business can make contributions financially and otherwise to this development agenda? So is there a bit of deliberate or intentional siloing that we need to overcome if we're serious about business and human rights? And then a second question for Nicola relates to COP26 and the Glasgow Declaration. And again, you had a few business and human rights groups there. What does she make of that, and where do we go? But my last and biggest question is really about, so we've identified the silo problem, and the permeability hasn't happened yet. Permeability happened in business and human rights, right? Norm creation in this bubble has occurred, But the question is that acceptable? And is that perhaps a natural journey? And the next decade is where we then make those interlinkages, or is it too late, right? Are these architectures so firmly embedded that as much as a business and human rights advocate or human rights group goes and tries to move into these tents, that it's too late, given the timelines that we have for these other important challenges?
Thank you, Anita. That's very interesting and important questions. Well, is it deliberate that the responsibilities of corporations aren't addressed in these different, or not addressed to the full extent that perhaps the potential that the UN Guiding Principles have? Well, I haven't yet had the opportunity to discuss the COP26, the Glasgow Declaration, in great depth. But if I look at the first analysis coming out of those proceedings, it seems that there hasn't been a lot of change compared to the Paris Agreement. There is still hardly any reference to the UN Guiding Principles or to business responsibilities. And some say that human rights have been sidelined quite beyond. They're mentioned in the preamble, but not much more than that. The special rapporteur on the human rights and the environment, David Boyd, was quite strong in his response. He said it's the fact that human rights approaches are resisted by wealthy states is nothing more, is absolutely completely deliberate, because it's about accountability. That's what the special rapporteur said. And so that doesn't bode well for any uptake by states to be much more explicit on the responsibilities of corporations when they are involved in mitigation actions and adaptation activities. So I've seen little advancement from the Paris Agreement to the Glasgow Agreement. And is it too late? Well, I think I'm an optimist. I don't think it's ever too late, but I think it's a very important question to ask ourselves: what makes for change? Why does law change? How does governance change to be able to better understand what it takes to permit these silos to really influence for the business and human rights narrative to really influence other silos?
If we can take a moment here, because we have a lot of activity in the chat room that I would like to share with you, Nicola. Going backwards, Caroline Rees says, as he looks to develop human rights and environmental due diligence, she asks, is this an opportunity to recouple what has become falsely decoupled? And then earlier from Sarah Kavanaugh, the question to you, Professor Jägers, is there a role for the OECD guidelines on MNEs on RBC in addressing policy silos? I'll give you a moment to address those two questions, and then Anita, you a chance to give a quick closing comment.
Yes, is there a role for the OECD guidelines? I think that's an interesting option there, because there's a clear space there for both human rights and for the environment. And in many ways, it's the only kind of enforcement mechanism, it's not, by lack of a better word, that we have for the UN Guiding Principles. So if we have really active, efficient national contact points, I think they can really connect the environmental narrative with the human rights narrative. And I'm sorry, I missed the first question.
It was, Caroline Rees commented that as the EU looks to develop mandatory human rights and environmental due diligence, she asked whether this is an opportunity to recouple what has become so falsely decoupled.
Yes, I think that's a really interesting observation, because we do see that happening now in these mandatory human rights due diligence laws, that they're starting to incorporate the environmental narrative more. So that could indeed be a really interesting option to couple the two again.
Thank you, Anita. A quick last word, and then if you can transition right to your primary.
Last reflections, and one of them relates to, again, maybe these other spaces, whether it's the EU or it's the OECD, are the places to recouple or to connect, because the UN itself is so fractured in terms of competence, right? That this is one of the problems. Environment security, human rights, development are all placed in different spaces, and never do they meet really. So I think that's a challenge. But the second one is, and Nicola, I'd really encourage you to think about this, is really corporate capture, right? That corporations have tremendous influence in terms of global lobbying, and we talk about greenwashing, or we look at many number of sectors. And there's a question about how do we really try to change corporate engagement, because again, the linkages that we so desperately want may be forestalled by the influence of global lobbying and engagement in policymaking. So with that, I'll shift and just say, my paper is really focused on, I think, some very simple ideas, but really focusing on what have we missed in a decade of the guiding principles. And my focus was on what I call professional advisors or professional service providers. These are all the gatekeepers that companies need and hire to help them navigate the world of commerce. These are architects, these are bankers, these are lawyers, these are accountants, these is McKinsey and as management consultants, who has been really criticized for any number of advice it's given its clients, from the OxyContin opioid debate to advising, I think, repressive regimes in ways that are not human rights compliant. So the question is, what about these gatekeepers? I'm a scholar that really is interested in the role of these professions. As someone who is focused on corruption in banking, there has been a reluctance of these gatekeepers, particularly lawyers in the area of corruption, for example, to be brought into the regulatory fold. And they have given any number of arguments as to why they should be outside of regulation and outside of ethical obligation in their role as advisors. And so my point in the business and human rights world is that we have all of these professional service providers that have very much been left out of the debate when it comes to the way in which they approach their business models, so that you can have a law firm on the one hand with a business and human rights practice group that is being paid to provide advice to clients, but then has any number of other corporate clients that are being provided general corporate advice. And in that general corporate transactional, you name the numbers of practices, litigation, are doing things wholly inconsistent with the guiding principles. And the question is, where is the coherence there, and how do we really manage that? So as I move forward into the next decade in my own work, very interested in, number one, what role should these advisors have? Should they be advisors, or should they be enablers, which very often they are, of human rights abuses? There is a linkage. And how do we change that dynamic? And secondly, so that's one question. I think a second question is, and I'm working on a piece now on the business of business and human rights, which is we have all of these sort of entities that now make money from dealing with the guiding principles. And the question is, what ethical obligations do they have? On the one hand, there's a duty to their clients, and they want to, of course, maintain their relationships and keep business open. On the other hand, do they have ethical obligations to the rights holders who are there impacting, right? And this you see in the area of development consulting and aid as well. Who is your client? Is it the party paying? Or do you have a separate and independent ethical obligation when you're making this a business to deal with the people who are being impacted? And how does that shape the type of advice that you give? And what kind of competence should you have? So I think it's those two questions. Who should be in the tent? And what consistency do we have when we talk about advisors? And the second piece is the business of business and human rights.
Thank you, Anita. Professor Jägers, your response.
Yes, thank you. Thank you. Yes, thank you, Anita, for your presentation and the underlying article. I feel you bring a really important issue to the table. You made very clear your article with the many examples of the professional service providers, be it lawyers, consultants, and also I found that extremely interesting, architects. I hadn't actually thought of that category of service providers, how they have often been either part and parcel of illicit corporate conduct or simply blind to the wrongful conduct of clients. And I find it really interesting because it's something that's also being asked of us as professors more and more, that we educate our students to be aware of this, and that we're not just educating our students how to avoid taxes and things like that. And you make the point that service providers should apply the UN guiding principles to their work, and underlying is the premise that this will indeed lead to a more rights respecting role. And that brings me to my main question, and that's my concern with the position of rights holders. When service providers advise in accordance with the UNGPs, how do we make sure that this, at the end of the day, ultimately benefits rights holders? So how do we ensure that requirements such as human rights due diligence are not translated simply into compliance with processes. It also came to the fore in a debate between Professor Muchlinski and Caroline Rees. And so we've seen human rights due diligence, if it's a process towards continuous improvement, and there is this risk that it becomes more about compliance with the process than with stopping the actual negative impact. Well, and that brings me to my question. So against the, how do you view the development towards legislation across Europe? We've seen the mandatory human rights due diligence in relation to this need that you have identified to bring professional service providers into the fold, because we've seen that in the past, as soon as human rights due diligence becomes law, it's often not outcome oriented. So don't you fear that developments towards law will actually drive lawyers and consultants alike towards more compliance or more of a process oriented approach? And if I could just add one more question and then I'll stop, because building on this, don't we run the risk if we try to bring more lawyers and more consultants into the fold that we actually weaken the position of rights holders? So if human rights due diligence, which is still unfolding all this law, if that results in it becoming a shield for liability for human rights abuse, which is a fear that's out there, then we risk that we actually leave rights holders worse off. So I'm interested in hearing your views on the role of.
I think that all of these questions have been so underexplored that we've really just treated these advisors as merely that, and as sort of invisible actors that are there, but they're there at the Forum on Business and Human Rights every year handing out their cards. So the first question is, the fear that you have of sort of creating a compliance culture, which is well and alive in the anti-corruption space, is real. But that's real when you create a regulatory mandate for companies, right? That's as soon as we do that, that is already there, right? So we have to sort of figure out how to make the requirements for companies meaningful with civil liability or other enforcement mechanisms, such that their advisors are not basically just saying to them, tick the box. So the compliance culture problem exists outside of the role of the advisors. The advisors are going to benefit from that, right? That they're going to make money. But the second piece is, what do we do about these? What's the accountability of a management consultant or a lawyer? In my article, I start to look at those issues, which is that you really have accrediting and licensing bodies for some of the professions. And again, if we think about remedy and accountability, we're going to have to think about the role that regulators have for attorneys, for architects, and for others as part of that enforcement ecosystem. I don't have the answer now, but it really is the question, because management consultants, for example, aren't regulated. And so the question is going to be, who's going to hold a McKinsey accountable when there is this advice that leads to systemic human rights abuse? We're seeing a couple of cases in the courts now, which I mentioned in my article. So accountability of professional service providers is a very big issue. I don't have the answer now, but you're absolutely right. And then the largest issue is, how do we make this real for rights holders? I think that goes back to, again, linkage, and when linkage moves into a world that's much more like cause and contribute and connection, will that same civil liability apply to those that are providing the advice, which are in essence, they're the architects often of what the business does. So we need to take this seriously. And just last piece is that all of the mandatory human rights due diligence legislation that's coming out needs to include these bodies, right? The fear is, and particularly for lawyers, that they will seek an exclusion from regulation, right? Now, regulation won't solve the problem, but will exclusion be the right idea? I don't think so. So thanks.
Interesting. I don't see any questions for everybody. If I may ask one follow-up question to Professor Jägers, you said something very intriguing. I'm not sure if you picked up on this, Anita, but Professor Jägers suggested that accountability, if I read you correctly, might actually lead to worse outcomes for those whom we're trying to protect through the human rights regime. I'm just wondering, could you elaborate a little bit on that and give Anita a chance to respond to that? I didn't hear that followed up on as much as it intrigued me.
I can be very brief because I think it's a concern that's quite well known. There are quite some civil society actors also who pointed out that depending on how human rights, mandatory human rights due diligence will develop, in a sort of a worst case scenario from a rights holder's perspective, it could become a shield for liability. Saying if we simply follow the process, then there will be no legal liability. And in that case, rights holders will be worse off than they are now, right? Because now we see this litigation taking place. So there are quite some possibilities currently. And I think it's a very important question what the role of these legal professionals are going to be against that background. How are we going to make sure that they don't simply try to shield the company from liability?
And yeah, just to quickly say, and to Nicola's point, which is just, again, that if we create a compliance culture where somehow getting that legal advice or that opinion, almost like an auditor's letter, shields you, we're in a big problem, right? So we are worse off. So I don't disagree. I think the answer will really relate to what kind of standards and accountability mechanisms we have for the parties that are providing that advice, which is then relied upon. So it's an ecosystem, and we have to look at each of these bodies and say, what responsibilities do they have, but what obligations do they also have legally?
I see, Jen, you're here to remind us to go to move on, I take it.
So that's great. Thanks, Jen. And we'll now turn, and I'll play moderator, though, for our last duo, two non-legal scholars. But we have first Professor Andreas Rasche, who's going to talk about his paper, and Michael is his commentator. So Andrea, over to you. And there's a slide link in the chat so you can see a visual from his paper. Andrea.
Yeah, thanks very much indeed, Anita, and good evening from Copenhagen. So this paper together with Sandra Weddock from Boston, and well, as indicated, we're both non-legal scholars, so obviously we probably have a different take, at least on some of these issues. So our paper is a review of parts, and I think this is important to say, of parts of the academic literature on the UNGPs, journals, book chapters. So we ended up with 61 different pieces to review. And surprisingly, I mean, the contributions came from very different disciplines. And I think this already shows you, I think, that what has been created here as a discourse, I think, stretches across disciplines. And I think this is very important. We identified 4 main themes. And in the article, we then discuss what are the parallels and what are the implications for CSR or sustainability, as we call it nowadays in business schools. But it's essentially the same thing, unfortunately, as it was a couple of years ago when it was just called CSR. So the first cluster, the first theme really was around the critique of the UNGPs, which is, of course, given the ambition of a lot of scholars, not very surprising. Everybody likes to critique, right? And there were things like vague language, normative discussion. There was a lot of normative articles that we identified. And of course, that it is a weak instrument, particularly, and we came across this earlier, actually, when you look at this legal, non-legal dichotomy, of course, you can perceive it as a weak instrument. And all of this reminded Sandra and myself very much on our own early scholarship, and particularly my own, because it was on the Global Compact. And the Global Compact received very, very similar critique. It is vague, you know, it's about capture of the UN by private companies and so on. Whereas I always emphasize, well, you know, it's about norm creation. It's about norm entrepreneurs. And I think John Ruggie even used that language in his own writings about the Global Compact. So, but you see strong parallels here between these two discourses. The second theme is an application. So the literature is very application-based, which actually is good because there are lots of case discussions. We came across cases of applications of the UNGPs in the media industry, in the seafood industry. And all of this, of course, refers to a contextualization of the principles, which we viewed as extremely welcome, because in the CSR discourse, well, you have cases, but not that many, actually, not that many in the academic discourse in terms of really assessment of certain industries. So usually the discourse is rather generic, and I think there is an opportunity here to connect both discourses, and we also make the case for it in the paper. The third theme, the third cluster, was the embeddedness of the UNGPs in national and on the national and regional level. We came across quite a bit of literature, and we already discussed it here today, around the national contact points of the OECD, national action plans in terms of human rights. And these are, of course, implementation vehicles The CSR literature, on the other hand, emphasizes multi-level governance, but usually remains rather silent when it comes to specific tools. And again, we see a lot of opportunity here to connect both discourses, because the UNGP discourse seems to be kind of more reflective of these tools, which could be very helpful, I think, also for CSR scholars. And the last theme was, of course, no big surprise, due diligence. Quite a lot of articles on the different types of due diligence, and also inspiration of human rights due diligence for other frameworks. The IFC, for instance, redesigned its standards. This is what one article discussed. And we think probably here there is the biggest potential for connecting both discourses, because at the end of the day, due diligence is a management responsibility. Right, and I think this is also what we discussed a little earlier here. Is it a compliance responsibility or is it a management responsibility? And CSR scholars would usually argue, well, it's a management responsibility. It's not just a compliance responsibility. So, and in this sense, I think there is a lot of connection that is possible here, and that brings us also beyond this transactional view on due diligence, which I think John Ruggie also in the video that we saw very early kind of also criticized. You know, M&A due diligence is not the same as human rights due diligence, and I think this is very important to take away, and this is where I think both discourses can learn a lot. Thank you very much.
Great. Thank you for that summary of a very comprehensive article that I hope many of you will read. And Michael, over to you for your reaction.
Yes, thank you. Thank you, Anita. And thank you, Andreas, for this wonderful article that you and Sandra Waddick wrote for us. I'm very curious about the distinction that is implicit in this article between discourse and practice. And so I'm interested to ask you a few questions about, and I want to ask them about discourse and practice, right? So is CSR broader than BHR? Or can BHR encompass CSR? And I guess I want to ask that question about both discourse and practice, because what I'm most curious about, which you inch up to but don't quite answer, is where you see, is there going to be a melding between the discourse, and more importantly, really, is it going to be a melding in the practice? I'm struck. I remember one time I was working in Tanzania on a code of conduct for a company there, and there was a person from another company there, and I said, won't you be part of this new regime that we're going to create to ask companies to be accountable in this area as in a code of conduct cross-company way? And he looked at me and he said, you have no idea what my office looks like. He said, he was the director of CSR. He says, every day I get an entreaty for someone to be part of some self-reporting group or to be part of some scheme or elaborate system or guidelines that govern one industry or another. And he said, I literally get 5 or 10 of these a day. And so in CSR and business and human rights, we have two that have managed to make it into this room that companies have where they process these things. But I'm wondering, looking at it from the company's point of view, if this isn't very confusing to have spent decades thinking about CSR, and now you're being told, I need to think about BHR.
Great question, Michael. Andrea?
I think it's an excellent question, Michael. Discourse practice, well, I think we could probably spend a lot of time on this. It depends on who you ask, I think. If you ask a CSR scholar, they would say, well, CSR is the broader discourse, obviously. But I think I don't want to judge here. I probably also don't think it is about, one discourse being broader than the other, but more both discourses having cross-fertilization on the academic level. I think if we get there, that's totally fine by me. On the practice side, of course, I think it is even more interesting to kind of see as you just alluded to with your example, I mean, what will be happening? I think at least what we see here in Denmark is that a lot of the sustainability CSR departments, I mean, this is where you have these business and human rights discussions taking place. So I think, again, you will probably see a good cross-fertilization happening of both the human rights and the CSR sustainability part. What I see with a little bit of a, with a little bit of care or where I don't really know where the debate might go is that sustainability itself has a stronger environmental touch. And I think we already discussed it also today, that we might end up in a situation, you know, where it gets simply, you know, sucked up by all this climate debate and so on, where, you know, these questions do not really make it to the fore. So I think I just hope, you know, that it gets and retains an equal standing, not only within the academic discourse, but also within corporate practice. At least here in Denmark, this is the case, I can say, from my interactions with practitioners.
Great, thanks so much. Micro, over to you. And I see that Luis Ribeiro has a hand raised, but I think you need to either type your question in the Q&A or chat, and I'll monitor for that, Luis. Over to you, Michael, for your concluding remarks, and then we'll head into your presentation.
Well, I think I'm appreciative of Andrea's mature perspective and generous perspective of accommodation between the fields. I think that that'll be a discourse that will, I think, continue academically. Let's see if we have this last question for him, and if not, I'll turn to my presentation.
I think go ahead and we can come back to that, Michael, if we get it.
Yeah, so we are the outsiders, Andrea and I, and that we're the business ethicists, and Andrea, I think you seek to be an insider, and I have no such interest. You know, I find, you know, I remember, so my paper is really about how maybe it wasn't such a good idea, certainly for the BHR discourse, for all of this to be taking place at the United Nations, kind of the wrong place, in my view, for having a discourse on business and human rights, for a number of reasons. I mean, first of all, there's a kind of historical, you know, there's a historical reason why the UN is not a good place to think about the role of states in anything, and in BHR in particular. I mean, going back, you know, to the Article 39 of the UN Charter, which limited which limited UN intervention to breaches of peace and acts of aggression. This didn't really change when the UN Human Rights Council was formed, or the earlier Commission on Human Rights. You know, the UN is just reluctant to do anything about states who are the primary violators of business and human rights. At best, it is states and companies in tandem that are the worst human rights abusers, but more often than not, it is states. And I think there's a historical reason as well. This inability to hold states accountable, I think, made human rights activists turn in the past few decades to businesses. But what I see when I go to the UN forum, I mean, I just took a quick look before this panel began, and I looked at the UN forum and I saw nothing of interest there. I mean, absolutely none of the things that occupy people who think about human rights are being discussed there. The easy issues are being discussed, but China, nothing about China, nothing about the Uyghurs in China, nothing about political repression in China. Why? Because you can't have that discussion at the UN. My suspicion is that it would actually be outright objected to and banned. There's not, you know, another example that I give in my article is the inability of the UNGPs to address the biggest debate of the last year, which is access to COVID vaccines in the global South. people who work in BHR gave there was a lot of kind of very immature, uninformed discussion early on about how bad the pharmaceutical companies were. And I try to argue in the paper what the indispensable role of the pharmaceutical companies was in the development of COVID vaccines. And now, a year later, after some course correction and public discussion, the states have now realized, the United States and Europe have now realized it's their primary responsibility to provide these vaccines to the global south. And slowly, semi-surely, the rich states are beginning to pay for these vaccines, probably a little bit too much on the basis of self-interest, rather than the idea that the virus is not going to spread to us, rather than we owe this as a human right to people in the global south. But the UNGPs had none of that debate. They don't. It's difficult to discern how they would even be relevant to the debate, but they weren't part of it. They weren't part of the process of eventually forcing nations to live up to their responsibility. So I don't want to throw the baby out with the bathwater. A lot of good things have happened as a result of the UNGPs, but if we think for a moment that they are the discourse and frankly, even the practice of business and human rights, then we're missing a whole lot of things that need to remain in the discourse. And so I conclude my article by saying we need to have other spaces besides the UNGPs and besides the Serpentine Bar in Geneva for us to discuss business and human rights.
Great. Thank you so much, Michael. Andrea?
Yes, thank you, Michael. Great article. I really enjoyed reading it, and I can recommend it also to everyone here on this webinar. I have 2 points, Michael. The first is you say there's a neglect of states' own violation of human rights in the UNGP framework, and I must say I'm not a legal scholar. I'm a management scholar, so treat this carefully. But I think I'm not entirely sure about this. I mean, the UNGPs, they state in their general principles that the UNGPs are grounded in states' existing obligations to respect, protect, and fulfill human rights and fundamental freedoms. So I think there is some acknowledgement there. Maybe not to the level that you would like it, right? But then, of course, it is a question of how exactly you would like to have it acknowledged. And also, if you read the commentary to Principle 1, it states states international human rights law obligations require that they respect, protect, and fulfill the human rights of individuals within their territory and or jurisdiction. So I think there is some acknowledgement there. The question is, I think, just a question of level and maybe where to put it. My second point is you argue that the UN is not the right venue. I tend to agree with you in parts, also having collaborated with the Global Compact for a while and also knowing all the trouble that is and all the difficulties of this organization. But then my question would be a very simple one. If not the UN, where then? What other organization do we have that has the same level of authority and moral legitimacy than the UN? So I think, and what are the conditions to choose a venue to have this discourse? So these would be my 2 questions to you. But great article, I enjoyed it particularly because it is so timely regarding the COVID references that you made. So thanks for that.
Great, thank you. Michael, back to you. And then if there are any last questions or interventions, please do raise your hand or put them in the chat. And Michael, back to you.
Yeah, thank you, Andrea. Great questions. First, on the state role in the UNGPs, if you read it carefully or if you read the commentary, it's all about the states enforcing against companies, right? I in fact have this theory that Pillar 1 was poorly drafted because it says states have the primary duty to respect human rights and to protect human rights, and I thought if you read that baldly, it means that it's creating an obligation on states to themselves to not violate human rights, something which China and Russia signed on to when they were part of the Human Rights Council and they approved the UNGPs, but they don't they don't, I think this would be an interesting discussion, Andrea, among lawyers and ethicists, but I don't think that they say what you are attributing them to say. I don't think that they make any statement to the effect that states have obligations to their citizens, except to protect them from violations by businesses. And like I said, I vaguely toyed with writing an article about the draftsmanship of Pillar 1, because I think it actually, if you read it in a certain way, it would appear to state something that it doesn't actually mean. But on the question of where else, that is a great question, because of course the UN has great convening power, and we also see all of the positive developments that have occurred as a result of the promulgation of the UNGPs. And so we don't want to throw that out. Like, nothing that I'm saying should be interpreted to mean that the good work that the UNGPs have allowed is something that we need to take back or want to take back in other ways. I would argue that we just need to supplement it. And it's interesting, if you think about the world that we had before the UNGPs, it was very random, right? It was a disgruntled young man in his basement, in his in-laws' basement, that led a campaign against Nike. A very effective one. The asymmetry, the potential asymmetries of disorganized business and human rights activism was actually quite strong before the UNGPs. And so now, as we enter this institutionalized phase, what I'm concerned about is that kind of asymmetric random activism and also asymmetric activism from NGOs that are outside the system is somehow being co-opted by the UNGP. So what I would like to see is just a big life outside the UNGPs. I think from a scholarly perspective, it's very important, because there's only so many articles that can be written about due diligence and turning the UNGPs into treaties, and we're missing a whole lot of other subjects, which as business ethicists we know are part of the BHR discourse. But I would have, I think, a random supplement rather than a specific alternative venue is what I'm talking about.
Great, thanks so much, Michael. And I think for everybody who's joined us, thank you all, many of you active scholars and researchers and policymakers. So I hope you'll take a look at the articles, but also just see that there was a common refrain through this, right? In the next decade, we need to go into new places, environment, sustainability, sustainable development, beyond the UN, into other places, new actors. And so it's really about what next. And I thank you all for those reflections and for joining us. So this will be recorded, and a link will be shared with you so you can share it with your students and colleagues. Thanks so much. Thank you, panelists. Bye-bye.
Thank you, everyone, for joining. There will be a short survey at the end of the webinar should you wish to submit any more questions, and we will also be sharing a recording with any questions that we were unable to answer today. The BHRJ special issue on the UNGPs can be found on the journal's website, which you can find at cambridge.org/BHRJ. And on the website, you can also find a link to a second webinar that will be held this Friday if you're interested in that and it's suitable for your time zone. So many thanks again, and goodbye.